Okay, I'm back. I'm trying to be as consistent as I can. I was reading that Federal Trade Commission, the holder in due course. So let me read part 2. Let's see about getting over here to let me see here. Let's see if I'm sharing the right screen. Where would it be? Here? Yeah, here we go. Hopefully you can see that. Can everybody see this? All right, so we ended on page 9. So let's take a look and see. There's page 9. So financing a sale. This term is defined to include situations in which a seller within the commission's jurisdiction extends credit to a buyer and takes a written credit contract from the buyer in connection with an affected transaction. Sound like two things were just done just there. Yeah, because look. Okay. So the commission's jurisdiction extends credit to a buyer and then takes a written credit contract from the buyer in connection with an affected transaction, like if you're buying a car. All such situations are covered by the rule, and all contracts so executed, except credit card instruments, must contain the required notice. Credit card instruments are specifically exempted from the rule. Interesting. Wow. So if you go try to buy a car, that credit card, it's exempted from the rule? Interesting. This section is intended to be comprehensive in its coverage. Okay, well, let's see if we comprehend. Excuse me. Besides the credit card exemption, the only limitation is that the agreement itself must constitute a contract under the law of the local jurisdiction. A casual notation of retail credit extended made in a form that does not itself constitute a contract is not covered. What was that? A casual notation of retail credit extended made in a form that does not itself constitute a contract, is not covered. Such an instrument would not be a contract in itself, though it might be part of a contract or evidence of a contract, and would not be assignable. There is thus no reason to try to cover it. So I guess you got to have an actual contract. The rule does not, the rule does apply to open-end credit extended by sellers. Ooh. Or to series of sales, closed-end credit, when the credit is extended pursuant to a consumer credit contract. This includes those situations in which a master credit agreement is entered into at the outset of a buyer-seller relationship, and extensions of credit for specific purchases are made later through a charge slip, charge plate, or similar device. In the event that more than one written instrument contains or embodies the rights and duties of the buyer and seller, the rule does not require redundant, like over and over and over, placement of the notice. The notice need appear once in any location, which renders it a clear term or condition of the written credit agreement. Incorporation by reference in multiple credit documents is appropriate. Incorporation by reference in multiple credit documents is appropriate and satisfies the rule as long as the documentation makes it clear to both the consumer and any holder that the consumer's written credit obligation is subject to the notice. You know, that all caps 10 font notice. Okay, so in practical terms, this means that there is no need for re-execution of outstanding open-end credit contracts. It is sufficient if consumers are informed through a notation or sales slips on bills, and if the master files are tagged in any way sufficient to put a subsequent holder on notice under state law. Excuse me. Purchase money loans. General considerations. The rule states that a seller may not accept money, but what? Which a consumer obtained via a purchase money loan, as that term is defined in the rule, unless the consumer credit contract made in connection with the loan contains the required provision preserving the consumer's claims and defenses. Where a purchase money loan is used to finance a sale, the seller is obligated to ensure that the consumer's loan contract contains the required notice before he consummates the sale. Oh, consummate. So what is this? That the rule, the seller may not accept money, which is a consumer obtained via purchase money loan, as the term is defined in the rule, unless the consumer credit contract made in connection with the loan contains the required provision preserving that, that notice that they have, needs to say it there. Where a purchase money loan is used to finance a sale, the seller is obligated to ensure that the consumer's loan contract contains the required notice before he consummates the sale. So at the car dealership, that thing has got to say that right there, because that's the rule. So I would think that if it says that they have to have it, that it's there. Just saying. So it should be in our contracts. Well, let me see. What is this? The purchase money loan. What's this all about? Hey, where's my deal? Come on. Where is it here? The purchase money loan provisions of the rule must be read in the light of the commission statement of basis and purpose. The commission concluded that it is unfair for sellers to impose all risks of seller misconduct on consumer buyers by arranging credit terms which insulate the creditor from claims and defenses. It is therefore required sellers to use a notice in credit contracts which ensure that the buyer's duty to pay remains subject to the seller's reciprocal duty to keep his promises. Okay. So apparently, they have to keep theirs so that you keep yours, right? I wonder if that's like the lemon law thing, if your car breaks down right away, that's probably why you don't have to pay for it. Well, I think my aunt ended up having to buy another car and she kind of ate that first one, but I don't know. I have to find out about that. Because this right here would help her. So the commission has concluded that consumer claims and defenses must also be preserved when sellers arrange financing for their customers by means of referrals to direct lenders, or where sellers and direct lenders are affiliated with each other. Yeah, like Ford Motors. Yeah. Honda Finance, stuff like that. So where sellers and direct lenders are affiliated with each other, as well as when sellers take loan contracts and transfer them to third parties. Like, I'm going to take this to my credit union because of the better deal over there. Failure to include purchase money loans would make avoidance of the rule both easy and inevitable. In the course of the rulemaking proceedings, the Commission learned that where the use of promissory notes and waivers of defenses in indirect consumer contracts has been prohibited by state law, a marked increase in the use of direct loans to achieve the same ends has occurred. Whether direct or indirect financing is used, the basic problem of the separation of duties remains the same. So right here, an amendment which would apply this obligation to a third-party financer as well is now under consideration by the Federal Trade Commission. So that's the bottom of page 11. Let's go over here. The commission also concluded that when a creditor and a seller are working together to finance sales by means of consumer loans, the creditor has or should have access to information, resources, and business procedures which place him in a position to assess the likelihood of seller misconduct and make appropriate provisions for dealing with it. The creditor has access to sources of commercial information not easily available to the average consumer buyer. And if he transacts business with the seller repeatedly over a period of time, he knows from his own experience whether the seller is basically fair or not. A creditor who deals regularly with the seller is in a position to establish economic ways of shifting the risk back to the seller through recourse or reserve arrangements. Where there is no such established relationship between the seller and the lender, these reasons for the rule do not apply. The Commission concluded that the rule should not cover the situation where a buyer obtains financing from a lender who neither receives referrals from the seller nor is affiliated with the seller by common control, contract, or business arrangement. The intent of the rule is to define as purchase money loans those consumer loans made for the acquisition of goods or services from a particular seller and consummated under circumstances where a seller and a lender have established a relationship or course of dealing with one another, which is directed at financing sales. In such cases, and only in such cases, the rule requires the seller to ensure that the consumer's loan contract contains the notice. Okay. So when you're at the car dealership and they have the people that they work with, you know, in-house financing or I guess they work with people all the time, it's still their job to make sure that in that contract that the rule is going to be there and going to be all conspicuous. That's what I'm understanding that to mean. Tell me if you think it doesn't say that in the comments. In reaching its conclusions about the scope of the rule, the Commission was aware of the argument that a rule preserving consumers' claims and defenses in purchase money loan situations could make lenders hesitate to finance purchases from unfamiliar sellers, and that this might reduce the diversity of credit sources available to consumers. It recognized that a lender who places the required notice in loan agreements may feel compelled to keep himself abreast of the seller's practices and perhaps to police those practices to some extent. While the cost of such efforts might be small, it is clear that some costs and risks will be involved, and that a creditor may choose not to incur them when he is unfamiliar with the seller involved, since it is in the public interest to ensure that consumers have a multiplicity of credit sources available. The Commission established a rule that would not apply in contexts where the lack of connection between seller and lender would create difficulties. Okay. So that's probably like if you're at the Honda dealership, they have all these different buyers for the loan, like lenders, banks. Oh, you can go through Wachovia, you can go through World Savings, which is no longer, you can go through Wells Fargo, you can go through Chase. Yeah, so they already have like a, what do they call it, a relationship. But the seller, the car dealership would still want to have that all caps thing in there to say that, to show us that we have our rights. Especially if they, tried some new Bank of China or something like that, and they weren't sure about them. I mean, they still got to put that notice in the contract. So I gotta look at my contracts to see if it's in there. Okay, would create difficulties. Thus, the rule applies only when the seller is arranging credit through either an established pattern of referrals or affiliation. The complexities of the consumer credit market make it impossible to enumerate all situations in which a seller and lender may be engaging in purchase money loan financing. But the question should be clarified by the above discussion and by the following elaboration of the common sense purpose of the purchase money loan provision and its application to typical situations. 2. Specific purchase. The definition of purchase money loan refers to a purchase and reaches only those consumer loans which are primarily or exclusively applied to a discrete purchase of goods or services from a particular seller, where a consumer obtains a loan and uses the proceeds from multiple purchases from different sellers. The rule does not apply. It says dues. The specific purchase requirement implicit in the definition of purchase money loan has the effect of exempting most open-end loan agreements with lenders who are not sellers. For the most part, check overdraft accounts and other types of open lines of credit are not applied to a specific purchase at the time of the initial extension of credit. While one could take the view that credit is extended only when the open line is drawn upon, the staff does not believe that such a technical interpretation would serve the public interest. For all practical purposes, the extension is completed when the line is approved. This interpretation raises some possibility that open-end credit arrangements could be used in an attempt to evade the rule. It would be possible for an affiliated lender to set up his agreement in the form of an open-end credit transaction and simply make the first extension of credit an amount sufficient to complete the relevant purchase. That kind of reminds me, like when I went to the timeshare presentation, they said, well, Hilton has just taken over your resort for your timeshare. But if you would like to go to all of the Hilton all over the world, you just have to join Hilton's agreement. So we want to give you an application for an American Express card. And I'm like, what? What are you talking about? I already have 2 of those, maybe even 3. You go, well, this one's to help you with your down payment. So that they could secure that right there, boom. Because I think that's what they wanted to do, get you to do that part, the first extension of credit, an amount sufficient to complete the relevant purchase. And then, of course, they're like, yeah, by the way, it's going to be $30,000 or whatever. I'm like, I don't think so. Get out of my face. Okay, so in such a situation, the substance rather than the form of transaction would govern and the rule would apply. I might have to get a little bit more craftier. Like if they were to do that, like if I went to the timeshare presentation, I said, yeah, I want to do that. Then I'd have to make sure they had that notice all in big, on the contract. If they didn't, I'd be like, you know what? I think you're going to owe me that 30,000 of membership, whatever. I had to get a little bit more, less gentle as a dove and a little bit more wise as a serpent. I need to learn about this kind of stuff. So receipt by the consumer of some surplus loan proceeds does not of itself remove a loan from the purchase money loan category. The test is whether the loan is applied in whole or substantial part to a specific purchase, while the substantial part clause creates a slight area of uncertainty. It is necessary to have such a qualification to close what would otherwise be a gaping loophole. If the rule required that the entire advance be applied to the purchase, it would be easy for a related lender to exempt himself simply by advancing a few dollars extra. 3, relation between creditor and seller. Once the criterion that the loan be applied to a specific purchase of goods or services has been met, the rule imposes a further requirement before a consumer loan is classified as a purchase money loan. The specific seller who receives the proceeds of the loan must be engaged in the practice of referring loan customers to the lender, or he must be affiliated with the lender by common control, contract, or business arrangement. Yeah, I gotta let karma go out for a little bit. Hang on. Okay, I had to let karma out because she heard a rat. I had to go blow the trailer next door and make sure there wasn't any rats in there. Let me continue. Yeah. So I'm going to read this again just in case. Once the criterion that the loan be applied to a specific purchase of goods or services has been met, the rule imposes a further requirement before a consumer loan is classified as a purchase money loan. The specific seller who receives the proceeds of the loan must be engaged in the practice of referring loan customers to the lender, or he must be affiliated with the lender by common control, contract, or business arrangement. Referrals. The rule requires a seller to ensure that a consumer's loan contract contains the required notice. When the seller refers consumers to the creditor, the word refers is intended to reach those situations where a seller in the ordinary course of business is sending his buyers to a particular loan outlet or to a particular outlets for credit, which is to be used in the seller's establishment. In such circumstances, the seller is effectively arranging credit for his customers. No specific number of referrals is specific in the rule. The key distinction is between those instances where a seller is merely passing along information about places where his buyers may obtain credit, and those where a seller is acting as a conduit for financing and channeling borrowers to a particular lender or a limited group of lenders. The rule has taken common sense approach to the question of referrals. A seller refers consumers to the creditor, and when his conduct indicates that he is doing more than passively engaging in an information process. Where a seller regularly names or otherwise designates a particular loan outlet as a source of credit to be used by his buyers, he is referring consumers to the lender. Where the seller contacts a credit outlet on behalf of his buyers, he is engaging in referrals. Where a seller helps the buyer prepare lender's credit documents, he is engaging in referral. Ah, okay. You can hear Karma out there squeaking under my trailer next door. Where the seller suggests that there are loan outlets in the community or immediate vicinity which may handle consumer transactions, he's providing his customers with information and is not engaged in referrals. Like when he says, you can go to your credit union, that right there, he's not really engaged in a referral. The same thing is true where a seller, like let's say Ford or BMW or Mercedes, whatever, is true, where a seller provides his buyers with a list of local credit outlets and takes no other action provided the list is not furnished pursuant to a contract or business arrangement with the loan outlets. In short, where there is no communication whatsoever between a seller and a lender, there is no referral unless the seller is actively steering his customers to a pre-designated loan outlet for credit. Yeah, there's a credit shark guy over here, and since your credit is so bad, maybe you should go over there to that guy. Got some deals with that guy. A seller does not engage in a passive information process merely because of buyer solicitation, however. If a seller responds to a buyer request for assistance with specific referral, he's still making a referral. All right, I gotta pause. Wait. How do you do this? All right, hang on. Okay. I had to sneeze. I'm thinking about going outside and checking on Karma. I can hear her. But if she's gonna be noisy, you might have to go out there. Hey, Karma, quiet. To a buyer request for assistance with a specific referral, he is still making a referral. Finally, the test is whether the seller routinely refers his customers to a lender or lenders. It is not whether a particular buyer was referred. This means that once a seller is referring his customers to a lender, all loan contracts between that lender and buyers from that lender must contain the notice, that all caps paragraph, provided the specific purchase test is also met. Conversely, it means that an occasional referral, which is not part of a business routine of the seller, does not trigger the rule. Affiliation. The alternative criterion for establishing the relationship necessary for a purchase money loan is affiliation. The rule requires a seller to ensure that the notice is used in a consumer's loan contract where the seller is affiliated with the creditor by common control, contract, or business arrangement. Like Ford Motor or GMC or Honda Finance. This requirement is intended to cover the myriad situations where seller and lender are engaged in mutually beneficial effort to promote the seller's sales through the use of financiers, lending resources, and vice versa. The first type of affiliation is common control. The commission has concluded that when a creditor and a seller are functionally part of the same business entity, loans made by the lender for the financing of purchase from the seller should be subject to the rule. This applies if the two companies are owned by a holding company or by substantially the same individuals, if one is a subsidiary of the other, or if they are under common control in any other way. Like if you went to Ford, to go buy a truck or something, and it was like Ford Motor Services or something. Obviously, they're working together. You get an arrangement. So the other forms of affiliation are contract and business arrangement. The rule defines this as follows. Contract, any oral or written agreement, formal or informal, between a creditor and a seller, which contemplates or provides for cooperative or concerted activity in connection with the sale of goods or services to consumers of the financing thereof. Business arrangement, any understanding, procedure, course, or dealing or arrangement, formal or informal, between a creditor and a seller in connection with the sale of goods or services to consumers or the financing thereof. Boy, that train is loud. Wow. These definitions encompass all situations where a creditor and a seller are party to any agreement, arrangement, understanding, or mutually understood procedure, which is specifically related to retail sales or retail sales financing. Man, it would be nice to get wholesale. How about free? While the business arrangement or contract need not be formal in legal sense, it must be ongoing and clearly related to sales or sales financing. Cooperative activity on a continuing basis is what is specified by the rule. It will be impossible to enumerate every conceivable example of the arrangements or contracts which are reached by the rule's definitions. But here's some examples. So right here, maintenance of loan application forms in the office of the seller, joint participation in the processing of loan documents, creditors' referrals of customers to a sales outlet, payment of consideration to a seller for furnishing loan customers or to a creditor for furnishing sales prospects, floor planning or inventory financing arrangements, which include or contemplate the assignment of indirect paper or the referral of loan customers, active creditor participation in a sales program, joint advertising efforts. All right, so an agreement to purchase paper on an indirect basis. Oh. It is also important to emphasize what is not included in the term affiliation. The contract or business arrangement must be sales related. The rule is not intended to include the many possible business relationships that do not bear directly on the financing of consumer sales. For example, a commercial checking account is not an affiliation with the meaning of the rule, nor is a commercial credit agreement between the seller and a credit institution which has no relationship to consumer sales activities or the financing thereof. A commercial lease, the factoring of accounts receivable, a general business loan, or other similar commercial arrangements or contracts do not by themselves invoke the rule. By special provision, excuse me, an agreement specifically dealing with credit card operations between a credit card issuer and a seller does not constitute a business arrangement or a contract. The definition of creditor specifically excludes credit card transactions. It is also important to emphasize that the terms of business arrangement and contract require some continuity over time. The fact that a creditor and seller must confer over a particular transaction does not in itself create an arrangement. Thus, for example, the mere fact that a creditor issues a joint proceeds check to a seller and a buyer in order to perfect the security agreement under the Uniform Commercial Code is not a business arrangement or contract. That's interesting. Boy, this time at night, got coyotes, got the train, got the dog, all these. I want to focus on that last part. Thus, for example, check this out, what they're saying. The mere fact that a creditor issues a joint proceeds check to a seller and a buyer in order to perfect the security agreement. Ooh, under the Uniform Commercial Code is not a business arrangement or contract. What does that mean? Oh, you know what? I gotta go out there because I do hear coyotes and I hear my dog. Hang on. I gotta go. Okay, karma's back. Let me find that screen again. Here we go. All right, so that was interesting. You know, what we're talking about there, the mere fact that a creditor, let's say you were at Honda Finance, that's the creditor, issues a joint proceeds check to Honda dealership, and a buyer, in order to perfect the security agreement. That's interesting. I don't ever remember getting any money when I went to go buy a car where they give a check to the seller and to me. Maybe it's possible that could have been that incentive thing, you know, where they give you $500 if you go with Ford Motor or whoever, you know, could be that. They could be, oh, we're going to give you like $500. That right there. That could be that. So they do that to perfect the security agreement, huh? Interesting, under the Uniform Commercial Code. But that says is not a business arrangement or contract. Huh. Somebody tell me a little bit more about that. Put it in the comments, please. Finally, where the lender and the seller are affiliated, all loan contracts with consumers who use the proceeds at the seller's establishment must contain the required notice. This is true provided the specific purchase requirement is met, whether or not a particular loan is directly attributable to the affiliation. So, placement of the notice. The rule imposes no requirement with respect to the location of the notice within the text of the consumer credit contract. It may appear anywhere. The rule is satisfied as long as the notice is clearly a part of the contract. So I guess look at your contracts and see if it's all capitalized. If more than one document is used to consummate a subject to the rule, duplicative placement of the notice is not required. Insertion in one document only, plus incorporation by reference where necessary, is appropriate. The rule requires only that the documentation is used to make clear to both consumer and holder. Sounds like the consumer is not the holder. That the consumer's obligations under the contract are subject to the notice. Okay, so if the bank is the holder and we're the consumer, this is the rule of holder in due course. So we have to be doing the due course, though, in order to be holder in due course. So application of the rule to seller. Open-end credit plans and series of sales plans has been discussed above. With respect to those plans which are covered, the staff believes that extension of credit made after May 14, 1976, pursuant to agreements in existence before that date, are covered by the rule. This creates a logistical problem with respect to such pre-existing agreements. For future consumer accounts, the notice may be included in the master contract between the consumer and the seller. However, it would be wasteful to amend or rewrite existing master agreements to conform with the rule. For this reason, The staff believes that it will be sufficient if consumers are notified once in a monthly statement. That with respect to future purchases made pursuant to the existing master agreement, the required notice will become a term or condition of the consumer's credit obligation. Thereafter, the existing master agreement between the consumer and the seller may be tagged or marked to make it clear that the text of the notice is incorporated by reference therein for the purpose transactions occurring after May 14, 1976. Effective date of the rule. Any method sufficient to put an assignee on notice under state law is acceptable. And here's the effective date. The Commission promulgated its trade regulation rule concerning preservation of consumers' claims and defenses on November 14, 1975. An initial period of 6 months was specified to permit sellers to incorporate the required notice in their forms prior to the effective date of the rule. The rule becomes effective May 14, 1976. Proposed amendment. On the same day that the Commission adopted the rule, it proposed an amendment thereto for consideration. Sounds like a trust language there. In informal rulemaking proceedings pursuant to the Federal Trade Commission Improvement Act. The proposed amendment would not alter the purpose of the rule, nor would it extend or restrict the transactions covered by the rule. The proposed amendment would impose a duty of compliance directly on creditors as well as sellers in the transaction to what the present rule applies. So creditors would be the banks and the sellers would be the car dealers. The final Commission decision on the proposed amendment will be announced in the Federal Register. Advisory opinions. Under the rules of practice of the Federal Trade Commission, any person, partnership, or corporation may seek a formal advisory opinion with respect to a course of action the requesting party proposes to pursue. For details of the procedure to be followed, see sections 1.1 to 1.4 of the Commission Rules 16 CFR, subsections 1.1 to 1.4. Informal requests for advice will be answered by the staff of the Commission. Inquiries should be directed to Assistant Director for Compliance, Bureau of Consumer Protection, Federal Trade Commission, Washington, D.C., 20580. Wow. So what does it mean? Oh, there's a phone number down there too. 1877 FTC help or ftc.gov for the consumer. I guess we could call or find out, I think it mentioned something about up here, that one thing. Oh, was it page 17? Let me see. Yeah, here it is. The Uniform Commercial Code is not a business arrangement or contract. Well, what does it all mean, folks? If you have any suggestions, put it in the comments below. Anyways, I'm getting tired. I hope that this was beneficial or helpful to anybody. I am not one of those legal peoples, so I'm not giving any legal advice or telling anybody what anybody should do. But, we got to read this stuff for ourselves. So this way we kind of know, if we hear something, we should probably know where the source comes from. So that was good. So you have some information there. You can kind of look back, skip back over a few minutes, and you can always go to ftc.gov, read some more stuff for yourself, call a phone number. I don't know. I thought that was kind of interesting, that one part on page 17 where it said something about the Uniform Commercial Code. So the creditor gives us money and the seller money in order to do that security agreement. I thought that was interesting. And I've noticed those incentives too. Yeah, they say, hey, if you want to go with a Ford Motor or GMC or Honda or Nissan service, they have like this rebate. They have a rebate. I have a feeling that that rebate was the payment so that they could do the securities. What do you guys think? Write down in the comments, and please like, subscribe, share, but most of all, comment for sure, and like and subscribe. I'm gonna go to bed. I'm tired. Thank you guys for subscribing and liking and sharing and commenting. And Dr. Zoser, I love it when you comment down here too. You got some good things to say. Okay, well, what is today? Tuesday, October 18th. I'm getting sleepy for bed. Betty, bye. So have a good night, and meet me on Telegram. I opened up a new page, ChaYah Shalom, ChaYah Shalom. I also have reconnaissance study group where we just throw some files in there and we all can help each other. And like the last 3 weeks, I've been out of commission big time because of flu. So that wasn't fun. But sometimes you gotta take a break too, because sometimes finding out about all these things can maybe, do a number on you. But anyways, I got some flowers back there. Those are real. Anywho, my friend Tracy says that. You guys have a great evening, and I hope that this helped. Okay?